15 years, indicating that A is a natural object of O's bounty. O became depressed as a result of injuries suffered in an automobile accident. She commits suicide by jumping from the roof of the apartment building in which they lived. On the morning of her death, she receives a check for $17,400 in satisfaction of the claim. She endorses the check in blank, places it on the kitchen table with a handwritten note. A court that was predisposed not to sustain the gift, a court that was convinced that by sustaining the alleged gift, it might be sustaining a fraudulent claim, had any number of opportunities from these facts to refuse to sustain the gift. First, the cause of death is suicide. In the overwhelming majority of cases in which courts have sustained gifts causa mortis, the apprehended peril from which imminent death was feared was a malady, a sickness. Sometimes some other kind of external peril, but more often than not, sickness. Some courts that are predisposed not to sustain the gift have said that a gift made in contemplation of suicide simply does not satisfy the requirements of a gift causa mortis. I mean, you should be aware that some courts will say that. I find the policy behind that rule astonishing. Here's the policy. We want to discourage people from committing suicide. So a person who is contemplating suicide and who wants to make a gift causa mortis might say, gee, I know that the courts won't sustain my gift causa mortis if I commit suicide, so I won't commit suicide. I mean, right. That's the theory, at least, behind the rule, the older rule, that many courts would say, you can't make a gift causa mortis if the anticipated peril is that you're going to take your own life. Modern courts are less inclined to regard that policy or that argument as persuasive, and this is one of those courts. This court sustained the gift of the check as a gift causa mortis. The court didn't have to. It could have leapt upon this notion that the external peril was not an external peril. It was by the alleged donor's own hand, no gift causa mortis. But the court was convinced that to sustain the gift would have effectuated the intention of the maker of the check. Moreover, observe here, there was not a delivery, a personal delivery from the donor to the donee. Often, in gifts causa mortis, the courts insist upon more by way of delivery than in gifts inter vivos. Remembering that gifts causa mortis are willed substitutes. Remembering that typically the claimant, the alleged donee of a gift causa mortis, is going to make the claim after death has sealed the lips of the alleged donor, the courts will scrutinize the claim. They're suspicious. And some courts will say, there's a delivery requirement both for gifts inter vivos and gifts causa mortis, but if anything, we're more insistent upon delivery in gifts causa mortis than in gifts inter vivos, because of the suspicious nature of the gift. Well, having said all that, here's an example of a court that goes in the opposite direction. The delivery was sufficient under the circumstances. I mean, this is analogous to the notion that if you can't kill a finback whale with a harpoon and line, we'll say you did as much as under the circumstances could reasonably be asked. If a person is resolved to take their own life immediately, and they're living in the same place with the intended donee, this court says, well, under the circumstances, given the resolve of the donor to take her own life, leaving the check, the endorsed check, on the table with the note was as much of delivery as could be expected under the circumstances. This is an astonishing relaxation of our ordinary insistence, particularly in gifts causa mortis, that there be a physical delivery of the chattel from the donor to the donee, or, as we learn in the next chapter, from the donor to some third party for the donee. So, this case stands for the proposition that the court will sustain the gift causa mortis if there are enough facts that convince the court that by doing so, it will effectuate the alleged donor's intention. The court did sustain the gift of the check, the proceeds of the check, but as to the note that says, in the note in which she said she bequeathed everything she owned. Whether the court will sustain that expression of donative intent depends upon whether this state recognizes something called a holographic will. Mr. Baxter, what is a holographic will?
It's a will that's handwritten by the person making the will.
What distinguishes a holographic will from an ordinary garden variety will, besides the fact that the testator has written the will in his or her own handwriting?
The fact that he signed it and there's a witness that has seen him write it.
In a regular will?
Right.
What about in a holographic will? Are there witnesses to holographic wills? No. Holographic wills are an exception to the statute of wills in each state, which permit validation of a will if it's entirely in the handwriting, or at least certain essential parts of the writing are in the handwriting of the testator, signed by the testator. Each state has its own attitude as to whether it will enforce holographic wills. If this state would enforce holographic wills, and if that writing, that what seems to be somewhat informal writing, would be sustained as a holographic will, only in that circumstance would they also permit A to get everything else that O owned. So check the statutes in your individual state. Under the Uniform Probate Code, which has been widely adopted, holographic wills are enforceable. Happily, you don't need to know anything more about them than just simply an introduction into the topic that there is such a thing as a will entirely in the handwriting of the testator that is not attested by witnesses that may still be enforceable. Problem 510. O delivers to A for safekeeping $1 million in bearer bonds. 1 month later, O says to A, in the presence of a witness, good, that I hereby give you the bearer bonds you have been safekeeping for me. O dies and you are O's executor. Are you, as executor of O's estate, entitled to recover the bonds and include them as part of O's estate for disposition under O's will? The holding of the case is no. And the reason is the relationship that subsisted between O and A initially, as I hope everyone knows, was that of bailor and bailee. O, owning the bonds, delivered possession of the bonds to A for safekeeping, thereby constituting A bailee of the bonds. O subsequently resolved to make a gift of title in the bonds to the bailee. This is one of those lovely cases in which the cliche arises: the law does not require the doing of a useless act. Will the law insist that in order for B to acquire title to the bonds, B must re-deliver them to the bailee, who in turn, theoretically seconds later, re-delivers them back to the bailee as a delivery necessary to satisfy the requirement of delivery in a gift? The law does not require that. The bailee, already being in possession, already having received delivery of the goods, may become the owner of those goods if there is a sufficiently clear expression of donative intent by the bailor. In writing, in the presence of a witness. And so problem 5.10, like many of the others involving symbolical delivery with the recording of the cattle brand, involving constructive delivery, delivery of the keys to the lockbox rather than the contents themselves. Problem 5.10 is yet another example of a situation in which the law dispenses with the ordinary requirement of delivery, when under the circumstances the conviction abides that by doing so the court will be effectuating the intention of the former owner. We're not going to make the bailee re-deliver the bailed chattel to the bailor only for a subsequent re-delivery to effectuate the gift.